Hi everyone out there, Bernie Tully, personal injury lawyer from Pittsburgh at 412-281-8700 from the law firm of Tully and Tully. And I want to talk to you today about other questions we get from clients. They often ask is this: what do I do, or how do we catch them if the defendant's lying about how the accident happened? That's a legit question. In other words, it's an intersection collision, and the person maybe ran the red light or missed the stop sign, but then lo and behold, at your deposition, I stopped it, she never saw me. That's what we get a lot of times. And when clients read that, they were infuriated because the guy or the person is obviously lying. What do you do about that? And I try to tell people to be happy about that. Yeah, what's this guy, a weirdo? Why would you be happy if the defendant's lying in order to get out of the thing? Well, here's why. Suppose like he says that he missed, I stopped at a stop sign and I slowly proceeded out. If you have a couple witnesses, or if there's a witness that was there and said she never stopped at that, or he never stopped at that stop sign, he blew right through it, it's going to make the defendant on as a liar to a jury. And let me mention to you from my experience, nothing infuriates a jury more than a person lying under oath. So you should be happy when that happens, especially if there's independent witnesses. Another example, I told you this is Tully and Tully. My son Michael Tully took a deposition last week, and in the deposition he asked the client, the defendant, whether or not he had ever been something about suspended license, and the person said no. And lo and behold, we have the document that shows he was under a suspension. And then Michael asked him, well, are you sure about that, or words to that effect? He denied it. So that's a cause to be joyful. And the reason why is now all we have to do is, if this goes to trial, we're going to mark that as an exhibit. And if he says, I wasn't convicted of license suspension, we're going to have a certified document that's going to show he was. Now, what effect do you think that's going to have on a jury in a contested liability where he says, this, somehow was your client's fault? It's all ridiculous. If you have a certified record showing that what he said to under oath is not in fact what it is, how believable do you think that person is to a jury? And nothing, as I said before, nothing gets a jury more upset than thinking or hearing testimony where the person's lying. That's when they send out a message, and that's when you get a runaway verdict. So things that might upset you as a client sometimes can work to your benefit, because the truth will always come out. I'm a firm believer in that, and that's what the whole purpose of a jury trial is. So if you're in that situation, the defendant's lying, nothing to be worried about, nothing to be upset about. It will come out the right way, and a lot of times it'll come to our advantage. Bernie Tully, just talking about things that happen on an everyday basis at our law firm. That's what we're plugged into. We concentrate our practice in personal injury, car accidents type of cases where you're injured. We're here to help you, and we've been around long enough where you can see ways around anything that the defendant is doing to fabricate their testimony. Hope it helps. And I'm always available. My son, Michael Tully, Bernie Tully, 412-281-8700. We want to help you. Thank you. Bye.